Good afternoon and warm welcome to all of you dear students. In this session, we will focus on leading international instrument concerning intellectual property. First international instrument is the Bernese Convention for the Protection of Literary and Artistic Works, adopted on September 9, 1886 at Berne and enters into force on December 4, 1887. This convention on copyright rests on three basic principles: national treatment, automatic protection, and independence of protection. It also contains a series of provisions determining the minimum protection to be granted. It came into the force in India on April 1st, 1928. Second, Convention establishing the World Intellectual Property Organization, short form WIPO, adopted on July 14, 1967 at Stockholm and entered into force on April 26, 1970. WIPO was established under this convention with two main objectives. First, to promote the protection of intellectual property worldwide and to ensure administrative cooperation among the intellectual property unions established by the treaty that WIPO administers. India became a member on May 1, 1975. Next is Agreement establishing the World Trade Organization, adopted on April 15, 1994 at Marrakesh and entered into force on January 1, 1995. WTO was established to provide a common institutional framework for the conduct of trade relations among its members in matters related to the agreement and associated legal instrument. India became a member to this agreement on January 1st, 1995. Next is World Trade Organization, that is WTO Agreement on Trade Related Aspect of Intellectual Property Rights, TRIPS Agreement we called it, adopted on April 15, 1994 at Marrakesh and entered into force on January 1st, 1995. The TRIPS agreement covers various types of intellectual property and provides guidelines for minimum standard for protection, procedures and remedies for enforcement of IPR rights and for issues related to dispute settlement. India became a member on January 1st, 1995. Next is Paris Convention for the Protection of Industrial Property, adopted on March 20, 1883 at Paris and entered into force on July 7, 1884. It provides basic guidelines for the protection of industrial property, that is patent, utility model, industrial design, trademark, service marks, trade names, indication of source or appellations of origin, and the repression of unfair competition, and has substantive provision for national treatment, right of priority, and common rules. This treaty came into the force in India from December 7, 1998. Next is Patent Cooperation Treaty. We called it a PCT, adopted on June 19, 1970 at Washington, D.C. and entered into the force on January 24, 1978. It facilitates patent protection for an invention simultaneously in a large number of countries. It came into force in India from December 7, 1998. Next is Budapest Treaty on the International Recognition of the Deposits of Microorganisms for the purpose of patent procedure, adopted on April 28, 1977 at Budapest and entered into force on August 19, 1980. It provides guidelines for the deposition of microorganisms with any international depository authority for the purpose of patent procedure. This treaty came into the force in India from December 17, 2001. Next is Protocol relating to the Madrid Agreement concerning the international registration of mark, adopted on June 27, 1989 at Madrid and entered into the force on December 1, 1995. The Madrid Agreement facilitated the registration of trademark outside India. It came into force in India from July 8, 2013. Next point is that the intellectual property regime in India. First, we will focus on the National Intellectual Property Right Policy of India. Actually, the National Intellectual Property Right Policy 2016 was adopted in May 2016 as a vision document to guide future development of IPR in the country. Its clarion call is Creative India and Innovative India. It encompasses and brings to a single platform all IPRs, taking into account all interlinkages, and thus aims to create and exploit synergies between all forms of intellectual property, concerned statutes, and agency. It set in place an institutional mechanism for implementation, monitoring, and review. It aims to incorporate and adopt global best practices to the Indian scenario. Department of Industrial Policy and Promotion (DIPP), Ministry of Commerce, Government of India has been appointed as the nodal department to coordinate, guide and oversee the implementation and future development of IPR in India. The Cell for IPR Promotion and Management (CIPM), set up under the aegis of DIPP, is to be single point of reference. DIPP stands for Department of Industrial Policy and Promotion, for implementation of the objective of national IPR policy. India's IPR regime is in compliance with the WTO agreement on trade related aspect of intellectual property right, that we call it TRIPS. Next point is that the achievement under new IPR policy. There is an improvement in GII ranking. GII stands for Global Innovation Index. India's rank in the Global Innovation Index issued by WIPO has improved from 81st in 2015 to 52 place in 2019. It also helps to strengthening of institutional mechanism regarding IP protection and promotion, clearing backlogs and reducing pendency in IP application, and the augmentation of technical manpower by the government has resulted in drastic reduction in pendency in IP application. Automatic issuances of electronically generated patent and trademark certificate has also been introduced. An increase in patent and trademark filing. Patent filing have increased by nearly 7% in the first 8 months of 2018-19 vis-a-vis the corresponding period of 17-18. Trademark filing have increased by nearly 28% in this duration. IP process re-engineering. The Patent Rule 2003 have been amended to streamline processes and make them more user-friendly. Revamped trademark rule have been notified in 2017. Creating IPR awareness. IPR awareness program have been conducted in academic institutions, including rural school, through satellite communication, and for industry, police, customs, and judiciary. Technology and Innovation Support Center (TISCS), in conjunction with the WIPO TISC, have been established in various institutions across different states. First is the Copyright Act 1957 Copyright Act. Actually, the copyright protect the expression of an idea rather than the idea itself. Under Section 13 of the Copyright Act, a protection under copyright can be obtained for original literary, dramatic, musical, and artistic work, cinematographer films, and sound recording. Interestingly, a copyright protection can also be obtained for computer programs. A copyright is an exclusive right that is granted to a person to do or authorized to carry out certain activity with regards to copyright's work. For example, in case of literary, dramatic, or musical work, the owner is permitted to perform the work and make translation of such a work and make adaptation of the work. The Copyright Act under Section 17 clearly states that the author of the original work for which the protection under copyright has been obtained shall be the first owner of the work. Further, the owner has the right to license the copyright of their work to third party through a written agreement. In case of published literary work, dramatical work, and artistic work, copyright protection shall be provided to such a work for a term of 60 years in addition to the life of the author. Incidental to the protection awarded under a copyright, the Copyright Act also confirms certain special rights to the author. Under Section 57, an author or owner of the copyright work, even after assigning the work to another person, has the right to claim that authorship of the work and the right to claim damages with respect to any distortion, mutilation, or modification of the author's original work in the event such a distortion or any other act is damaging to the author's reputation. Next, in India, the Trademark Act 1999. The Trademark Act under Section 2 defines trademark as a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others and may include the shape of goods, their packaging and combination of colors. In simpler words, a trademark provides a protection for symbols, colors, shapes, words, etc., representing and relating to a good or a service. Further, India is a signatory to the Madrid Protocol under which trademark can be applied for and registered internationally. However, the prerequisites for filing and registering an international application under the Madrid Protocol in a foreign jurisdiction is that the mark need to be first filed in India. A protection afforded from the trademark registration is imperative as it protects the brand name, logo, sound, shape, and distinctively identify the goods services to the brand, bringing uniqueness to the mark. Also, the validity of a trademark registration is for an initial period of 10 years, which can be renewed perpetually for a successive period of 10 years, subject to timely filing of renewal application. The Patent Act 1970. The Patent Act bestows each inventor whose patent has been registered with certain rights, namely with respect to a patent for a product, the right to prevent third party from using, selling, making, importing, etc. the product without prior consent, and with respect to a process for which a patent is obtained, the right to prevent the third party from using, selling, offering, etc. a product obtained from that process without the prior consent of the original inventor. Further, India is actually a signatory in the Patent Cooperation Treaty, which permits an applicant to file an application for registration of an international patent. Upon filling such application, an inventor can obtain patent protection in multiple countries simultaneously. The Design Act 2000. A design under the Design Act Section 2 demands and include only the features of shape, configuration, pattern, ornaments or composition of lines or colors applied to any article whether in two-dimensional or three-dimensional or in both forms by any industrial process or means, whether manual, mechanical or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye. Furthermore, once a design is registered, the registered proprietor is afforded protection for an initial period of 10 years, which is extendable upon filling an application for extension for a period of 5 years. The Geographical Indication of Goods Act 1999, the GI Act. Many goods in India are widely popular owing to their place of origin. For instance, Darjeeling tea is unique and popular owing to many factors including but not limited to its origin, the skill set of the tea farmers of Darjeeling and the weather prevailing in that area. Other such example of products which have a bearing of the place of origin or factors specific to the place of origin include Banarasi sari and Basmati rice. A geographical indication is defined as an indication which identifies such a good as agriculture goods, natural goods, or manufactured goods as originating or manufactured in the territory of the country or a region or locality in that territory, where a given quality, reputation, or other characteristics of such a good is essentially attributable to its geographical origin, and in case where such a goods are manufactured goods, one of the activities of either the production or of processing or preparation of the goods concerned takes place in such a territory, region, or locality as the case may be. The Geographical Indication Act covers only goods such as agricultural goods, foodstuff, handicraft goods, manufactured goods, and natural goods. An application for registering a good under the Geographical Indication Act required a statement explaining how the geographical indication affects to the origin of the good in terms of the quality, characteristics and reputation of the good, the class of the good, particulars with regard the appearance of the geographical indication and the map of the territory, area, country where the good has originated. A registered geographical indication is awarded protection for a term of 10 years with the option of renewing and extending such a protection for further tenure of 10 years from the date of expiration of the original registration. Next is the Protection of Plant Varieties and Farmers' Rights Act 2001. Plant Varieties Act we called it. The objective of the Protection of Plant Varieties and Farmers' Rights Act 2007 is to recognize the rights of Indian farmers and to provide protection to plant varieties in order to encourage the growth and development of more plant varieties. In 1994, India became a member to the trade-related aspects of Intellectual Property Right Agreement, under which all members are required to accommodate and provide for the protection of plant variety, Article 27, 3b of TRIPS, and all plant variety that have been registered and awarded protection entered and recorded into National Register of Plant Varieties. The Plant Varieties Acts permit any breeder, farmer, and any person as authorized to apply for registration of a new plant variety. A new plant variety is registrable if it satisfies the condition of novelty, distinctiveness, uniformity, and stability. To elaborate the condition of novelty required, that at the date of filling the application, the plant variety must not be sold. Further, distinctiveness encompasses the requirement of having at least one distinguishing factor from all other existing and protected plant varieties. The requirement of uniformity means that all essential characteristics of the plant variety must be uniform. Lastly, the plant variety being registered for is required to be stable, meaning that the essential characteristics of the plant variety must remain unchanged after repeated propagation of such plant variety. The validity of registration for the protection of plant variety is for a period of 9 years in the case of tree and vines, and for a period of 6 years in the case of crops, with the option of renewal of such registration. Next is the Semiconductor Integrated Circuit Layout Design Act 2000. A semiconductor integrated circuit is defined as a product having transistor and other circuitry element which are inseparably formed on the semiconductor material or an or insulating material or inside the semiconductor material and designed to perform an electronic circuitry function. Under the CI/CLD Act, all layout design capable of being registered are required to be original, commercially unexploited anywhere in India and in any convention countries, inherently distinctive and inherently distinguishable from other registered layout design. An application for registration of design layout has to be writing and is required to be filed before the registrar in the Semiconductor Integrated Circuit Layout Design Registry present in the territorial limits of the principal place of business for the applicant. Further, the protection affordable to registered layout design is 10 years. In conclusion, I would like to point out some important point, that is India has made a number of changes in its IPR regime to increase efficiency and has cut down the time required to issue patent. The culture of innovation is taking center stage in the country, and India is well poised to focus on research and development. This has been reflected in its improved ranking in Global Innovation Index over the year. Government efforts to strengthen national IPR policy, IP Appellate Tribunal, e-governance, and commitment to abide by TRIPS agreement of WTO in letter and spirit will help in improving the perception of India globally. An efficient and equitable intellectual property system can help all countries to realize intellectual property potential as a catalyst for economic development and social and cultural well-being. In India, there are different forms of intellectual property right allowing a person to obtain a protection for their asset. India has actively become a party to many conventions and treaties in order to afford international recognition and protection for intellectual property rights recognized in India. Some conventions have led India to introduce new enactments such as Plant Variety Act in order to award protection to goods that represent the heritage, agricultural background, and fauna of India. So, thank you so much, all of you.